Legal matter. Ready, start. A preliminary objection which has been raised at the hearing of the special appeal is that, having due regard to the provisions of Chapter 8, Rules 5 of the Allahabad High Court Rules 1952, a special appeal would not be maintainable against the order of the learned single judge. Full stop. Dealing with this submission, it has been urged on behalf of the appellants that the contention of the appellants is that the learned single judge has transgressed the jurisdiction which was invoked in the form of a writ petition under Article 226 of the Constitution for the challenging an order of the prescribed authority declining to stay the execution. Full stop. In a writ petition, challenging the order of the prescribed authority declining to grant stay of execution, it was urged that the learned single judge has not only set aside the original decree, but has also set aside the execution proceedings and even rejected the subsequent prayer for return of the plant. Full stop. In these circumstances, it has been urged that as a result of the impugned order of the learned single judge, which arose from a writ petition challenging an order declining to stay the prosecution, the original proceedings have been set aside, the appeal stands concluded and the appellants are foreclosed even from pursuing their rights and remedies in accordance with law. Full stop. Para. We find merit in the submission of the appellants that the special appeal would not be barred by the provisions of Chapter 8, Rules 5 of the Rules of the Court. Full stop. In the present case, the order of the learned single judge is assailed in the special appeal on the ground that in issuing the aforesaid directions, the learned single judge has transgressed the limitations on the jurisdiction of the court under Article 226 of the Constitution. Full stop. As we have indicated, the limited player before the learned single judge was a challenge to the order dated 30 October 2015, declining stay of execution of the decree passed by the prescribed authority in suit number 19 of 2013. Full stop. The learned single judge, in the limited issue which had arisen before her, was called upon to decide whether a case was made out for stay for education of the decree or otherwise pending disposal of the appeal before the district judge. Full stop. The learned single judge has not confirmed the decision of the court merely to this aspect. Full stop. The learned single judge holds that the decree itself has to be set aside and has accordingly set aside the release order dated 14 July 2040. Full stop. The execution proceedings have been set aside. Full stop. Moreover, the prayer made by the appellants for return of the planet of plant has also been rejected full stop as a result of the last of the directions comma the appellants have been foreclosed for seeking remedies which are available in law full stop in this view of the matter comma the learned single judge has acted in excess of jurisdiction hence comma it cannot be held that the special appeal is not maintainable under Chapter 8, Rules 5 of the Rules of the Court.